Hello everyone, this is Tom Fox. I'm extraordinarily pleased to present to you the first episode in my new podcast series entitled the FCPA Compliance and Ethics Report. As many of you will remember, I was privileged to do a podcast with Howard Sklar over the past couple of years, which was entitled This Week in FCPA. Howard has gone off to bigger and better things in the corporate world, so I'm going to start this podcast to hopefully fill in the gaps of where and the whys and the hows on FCPA, compliance and ethics, give you a little insight, talk about some of the week's most current events, and dive into the nuts and bolts of compliance in a little more detail. So for instance, in episode 2, we're going to have Matt Ellis, who will talk to us about the new Brazilian anti-corruption and anti-bribery law and an in-depth interview. So I hope you'll find this interesting. I will try to present to you on a regular basis some of the most relevant compliance topics. Today I want to start out episode 1 by focusing on, or at least starting with a focus on China. As I think most people are aware, GlaxoSmithKline got into a fair amount of FCPA, Bribery Act, and domestic Chinese law hot water over the past 6 to 8 weeks regarding allegations of bribery and corruption in China. The GSK is accused of paying massive amounts of money through certain travel agencies in China to fund bribes for doctors, physicians, and hospital administrators to prescribe GSK products in China. There's lots of interesting things about this case, lots of lessons learned for the compliance practitioner. If you're interested in a detailed discussion of these, I've recently published an ebook called GSK in China, A Game Changer in Compliance. You can purchase that on Amazon Kindle site, available in ebook form only. And through September 5th, it's available free for download at Corporate Compliance Insights through an exclusive arrangement with them, Corporate Compliance Insights, CCI, and Maurice Gilbert. I'm able to offer this ebook to you. I've got lots of detailed information about the background facts in the GSK matter, some of the peculiarities of Chinese law, which allows the Chinese to engage in investigations against GSK employees, and even those who were working with and for GSK as third parties. I have a section in there about employee obligations and employees engaging in bribery and corruption in addition to third parties. I talk about the obligations of boards of directors for companies doing business in China. I look at industry sweeps and ask, is perhaps a country sweep coming to China or the Far East? And I think some of the other information we're going to talk about today may lend itself to that interpretation. One of the things that I think GSK has done, in addition to the Walmart case from last year and moving forward, is put one more death knell or nail of death in the coffin of any affirmative compliance defense under the FCPA. I give you some specific information on the types of investigations and techniques you can use to try to protect yourself in China. And then lastly, I sum it up with what does it all mean? And I think what it means is probably the most significant thing for compliance and ethics going forward in 2013. And that's the entry of China into the international stage of anti-bribery and anti-corruption. China does have an international or an FCPA equivalent law, but the GSK employees and third parties got into trouble for violation of domestic Chinese law, which prevents or makes illegal bribery and corruption of public officials. Certainly, every country in the world, indeed, has that type of domestic law. But this is the first instance that we're aware of that a large Western company has come under such scrutiny. Many GSK officers and directors, high-level employees from their China operation were detained and arrested or put under house arrest. For instance, the CFO was prevented from leaving the country at one point. The general counsel of the GSK China operation was put under house arrest. Several high-level executives in the Chinese operation were arrested and indeed made public confessions on television that they had engaged in bribery and corruption. The company itself, after a couple of weeks, issued a statement, public statement, which they termed an apology to the Chinese people for the company engaging in this conduct. So this is really the first time we have seen a Western company come to grief for violation of domestic Chinese laws. The Chinese have been aggressive in prosecuting their own citizens for bribery and corruption. A couple of the examples we've seen over the past week are and I know I'm going to butcher this name, the Bo Xilai trial, where Bo is accused of party boss from a northern China region, was accused of massive corruption. He blamed his wife and those around him for taking advantage of the situation. Nevertheless, he was put on trial. His wife was put on trial for engineering the murder of a British citizen who was in her employ, was convicted. His trial has ended this week. We do not have a verdict as yet. This was a very public, very show trial. Lots of allegations against Bo individually and his family members for corruption. So it's going to be interesting to see what punishment he receives. But one of the more spectacular falls from grace, as Bo was alleged to, or perhaps would have been in line to become a member of the ruling Communist Party board in China. The second instance of prosecution of a Chinese citizen for receiving bribes is the gentleman who's called the smiling, grinning official. And this was reported by the FCPA blog that there was a very bad automobile accident, and indeed trucking accident, where the provincial safety administrator was seen at the scene of the accident where 36 people died, smiling and grinning, and even wearing very expensive watches to the tune of a $6,000 Rolex. This public display of a lack of humility, I think, probably went a long way to his downfall. Nevertheless, he was termed the grinning official, and he was publicly charged and convicted this week. So a couple of examples of, in the Bo trial and the grinning official, of the Chinese going after their own citizens for engaging in bribery and corruption. But going forward from the GSK matter through July and into August of this year have been a couple of other related developments that have come out of China. The first one is Peter Humphrey and China Ways. Peter Humphrey and his wife had a third-party investigative service that apparently GSK utilized. This investigative service did background investigations for various third parties, but certainly GSK. Peter Humphreys is a UK citizen. His wife, although I believe born in China, was a naturalized US citizen. Humphreys had previously worked at Kroll and had worked at PwC, both in their China operations, and in both jobs he had engaged in doing due diligence. So he was an old China hand. He apparently had been there quite a while, was quite adept in the ways of performing due diligence in China. Well, he was arrested and first put under house arrest, and then both he and his wife were arrested for obtaining illegal information under Chinese law. This has really very significant implications for all Western companies who are trying to do due diligence in China. It's as with many things in China, the precise laws are not clear and a bit murky indeed as to what you can and cannot do sometimes in China in terms of getting information, obtaining of information. While I wouldn't say the privacy laws are up to the United States or the EU, they certainly do have privacy laws in China. And they generally revolve around getting personal information, financial records, properties owned, that sort of thing. Well, apparently Mr. Humphreys obtained that information. He obtained it illegally, and he was convicted or at least arrested for this. This is going to make doing due diligence a very tricky matter in China, coupled with now the need to absolutely perform due diligence in China. One of the things that I mentioned that GSK caused GSK to come to grief was their use of travel agencies as a mechanism by which to pay bribes. Travel agencies in China have a different function than they do here in the United States or perhaps in Europe as well, where you and I might go to a travel agent to buy a ticket, book a holiday, help with a particular travel issue. In China, travel agencies put together conferences, put the whole packages together, hotels, travel, business courtesies, gifts, entertainment, arrange the whole thing and charge bulk rates for this. So one of the mechanisms to pay bribes was to have the travel agencies actually pay for first-class travel, five-star hotels, very high and very large gifts and entertainment, which went to Chinese officials who attended these conferences. But more than simply giving these lavish gifts and paying for first-class travel and five-star accommodations, these travel agencies would dummy up fake invoices. One of the problems that I go into some detail in the book is the problem of fake invoices in China. This is a situation where the invoice itself may be valid, so that you may have a valid invoice from a hotel showing that 100 people gathered for a conference, rooms were paid for, food was paid for, travel was arranged, but the information on that valid piece of paper is not correct, so that a company would pay that, the funds would be there, and it would be distributed as bribes. It's not clear what mechanism was used by GSK, but that's certainly one that is fairly well known in China and presents significant problems to Western companies, because you have to audit those, and you have to audit those invoices with a very fine tooth comb, getting down to actually contacting the hotels where the alleged conferences occurred and getting their cooperation and providing of information. So now you really are going to have to audit and take a very hard look at the information that is in the invoices to these third parties. But one of the things that came up in the information about the specific third-party travel agencies that GSK was involved in is they appeared to have been created out of nowhere, meaning around 2009 or so. This travel agency popped up. The principals had never been in the travel agency business in China, had been in other industries, so that's obviously a red flag as to understand why someone could move to a different business. But that's one of the things that you need to try to determine. What were their prior jobs? What was their prior experience? Why did the company get formed? How did it get formed? All of those questions must be explored. And with the Humphreys arrest, it's becoming less clear what information you can legally get in China, out of China, regarding prior employment and those sorts of things. So it may make it difficult in the face of what probably is going to be rather intense scrutiny by not only the Chinese government, but obviously the United States government and the UK government. GSK is a UK domiciled company. Clearly, if there are violations or allegations of bribery and corruption that would implicate the FCPA, that would also implicate the UK Bribery Act. And while it hasn't been publicly announced, I would certainly speculate that the Chinese prosecuting and investigative authorities will be sharing their information with their counterparts in the United Kingdom and the United States. The United States has worked very hard to help other countries put together investigative staffs to help them in their own corruption investigations, and we may be seeing one of the first instances of true international cooperation in terms of the investigation. So it's going to be very interesting to see that. It's going to be also interesting to see the Serious Fraud Office's response. I think David Green has made it clear that his number one priority is the LIBOR scandal. And if that is correct, it's going to be interesting to see how much time and resources can be of his office can be dedicated to this. There are several open allegations of bribery against UK companies or UK domiciled companies, so it's going to be interesting to see how this plays out in terms of the UK Bribery Act and what defense GSK may try to marshal to any prosecution under the Bribery Act, because unlike the FCPA, there is an affirmative defense under the UK Bribery Act. That's adequate procedures. If a company has an adequate procedures compliance program, there is a defense to a respondeat superior claim against a parent. It does sort of beg the question of what is an adequate procedures if you spend $500 million over 5 years to a travel agency and that was never picked up by any internal audit or any other internal investigative function to at least raise a red flag and to call that into question. GSK had a lot of scrutiny on it because in the summer of 2012 it had signed a $3 billion, that's billion as in billion dollar, settlement with the U.S. government, the Food and Drug Administration, for fraud and false labeling of its products and in marketing. One of the requirements of that settlement was just came to enter into a corporate integrity agreement where they were required to have compliance programs not only for food and labeling in their pharmaceuticals, but also with the FCPA. So it's not clear how robust their program had been or was if indeed they had engaged in such behavior for a period of several years and it was never picked up. So a lot of scrutiny under GSK, a lot of very interesting jurisdictional issues, and I think if you're a compliance practitioner out there and you follow the GSK matter, you will find that lots of lessons learned, lots of things for you to look at in your program. Are you using travel agents in China? What level of due diligence have you been able to obtain on any of your third parties? Have you audited not only your third parties in China, but your own employee expense reports in China? And I say that because last December in the Eli Lilly SEC FCPA settlement action, one of the bribery schemes that was utilized by Lilly was that its Chinese employees would turn in inflated expense reports and take that extra money to utilize to pay bribes to sell Lilly products in China. So I think we have at least now two instances, or at least one instance and one allegation of how bribery schemes can work. With Lilly, it was its own employees. With GSK, it's alleged to be third parties. So if you have these operations in China, you need to look at this very closely. If you are on a board of directors of a company with Chinese operations, you need to start asking questions from your chief compliance officer now about what they're taking a look at in China and how they are managing those risks that are known in China. So once again, take a look at my ebook. If you'd like to buy it, I'd love for you to do so. But if you go to the CCI site over the next, 5 days, it's going to be available for download for free. I invite you to take a look at that and use that to compare to or contrast with your compliance program or in your business operations in China to see if there's something else you need to take a look at. And I'd like to end this first episode by talking about something that's come up out of China. It obviously has much broader implications for compliance across the globe. And sorry, Howard, but we have to talk about it. JPMorgan and their hiring of sons and daughters of Chinese governmental officials. This story broke last week where the U.S. Department of Justice and the Securities and Exchange Commission are investigating JPMorgan for their hiring of Chinese governmental officials, sons and daughters. Apparently, JPMorgan had a program which, in the middle of the last decade, which identified family members of government officials so that they could receive extra scrutiny to keep the company out of FCPA hot water by hiring a family member and then having business be generated from that governmental official. Somehow that program changed to where they were now targeting family members for hire of, and then attracting business for JPMorgan. Unfortunately, the program was called Sons and Daughters, and it was apparently a formal program in JPMorgan Chase. And as reported this past week in the FCPA blog and in other locations, there was actually a spreadsheet of information about the people who were targeted to be hired, the sons and daughters, the governmental officials who were their family members, and then specific contracts or business JPMorgan was trying to obtain. So if it was or if you recall under the FCPA, it is anything of value. It doesn't have to be money. It doesn't have to be a gift. It doesn't have to be travel. It can be hiring of a son and daughter. And if you obtain or retain business through the hiring of a son or a daughter, I think that's something the government is going to look at very closely. The JPMorgan has hired a very prestigious firm to do an internal investigation, and of course they're cooperating with the government. But near the end of the week, we had information that there were additional companies who were being investigated by the government for the same or similar circumstances under JPMorgan, and it indeed was expanding outside of China. So that is, I think, something that is going to be looked at very closely. And the other thing that comes out of the JPMorgan matter is it's really the first time the government has focused on financial institutions in a big way under the FCPA. Obviously, this hiring practice it's the first time we know of the government's looked at these hiring practices. But one commentator in a New York Times article said that the government had been looking for a test case to use on financial institutions. This may be it. This may be the leverage they need to take a look at financial institutions from hiring policies and other financial institutions. If that's true, this could be the start of a long-awaited industry sweep, which we think the government has signaled several times over the past 18 months, and this may be the first time it's become a public knowledge. So very, very interesting matters. And if you're a compliance officer out there, there's some questions that you need to ask about hiring. And I'd like to just take these. Mike Volkov wrote an excellent blog on this, and he had 10 questions that he thought were key when it comes to hiring. And I'd just like to read these because I think they are really spot on. Who, if anyone at the company, is sponsoring or supporting the applicant? How did this applicant come to the company's attention? What is the applicant's relationship to the foreign official? What involvement, if any, has the foreign official with the company's relating to the applicant's interest? In which office or division does the foreign official serve? How important is the specific office or division to the company's business relationship with the foreign government? Is the applicant qualified for the position that he or she has received? Has the applicant or will the applicant be subject to the normal hiring process? Has the company completed a due diligence review of the applicant and the foreign official to identify any corruption risks? And has the company or the representative provided any assurance to the foreign official or to the applicant that the applicant will be hired? So this is a type of analysis you need to look at. I often say the three most important things about FCPA compliance are document, document, document. I think the JPMorgan hiring investigation clearly or makes this even more clear, because no matter what Morgan did, if it's not documented properly, I think the government will assume that it was done for a reason that should at least be questioned. So all of your hiring decisions need to be documented. All of the questions that Mike Volkov has posed need to be answered, but they need to be answered in writing, and that writing needs to be documented in a way that it can be called up if a government regulator wants to see this. You may not have looked as closely in the past at HR's role in FCPA compliance, but this is a very good opportunity for you to work with, if you're a chief compliance officer or a compliance practitioner, to work with your HR department for FCPA compliance. So starting with GSK at the end of June and early July, through the Peter Humphreys and the Ways matter, the Bow trial, the grinning official matter, and ending up here with JPMorgan at the end of August. It's really been a pretty incredible ride over the past couple of months for FCPA compliance and ethics, anti-corruption compliance and ethics, and anti-bribery compliance and ethics in China and moving towards the Far East. And I think you can see the arc moving from China to the United States, and it may move back and forth several times again. These are some of the things that I hope I can highlight to you in my podcast going forward. I certainly hope that you would contact me if you have any questions. I can be reached at tfox@tfoxlaw.com. I blog every day on the FCPA Compliance and Ethics blog. And sorry, but of course I have to talk about my second book, which hopefully you can see here. Best Practices under the FCPA and Bribery Act. It came out in April. It's available at Amazon.com. A ebook version has just been made available on Kindle, so you can pick that up as well. If you have any comments, please hope you would contact me regarding those. If you'd like to be interviewed by me, please let me know. I hope to have a wide variety of guests going forward, and I hope that I can provide to you some solid information that you can use as a compliance practitioner going forward. So that's the end of episode 1, and I hope you will turn in for episode 2, which will be my interview with Matt Ellis. Thank you.